everyone again. Good evening, everybody. Welcome to our Protecting Your Legacy Landowner webinar. And the first thing I'd like to do before we get going is just make sure that everyone feels comfortable with that chat box. So what I'm going to ask you to do is to type into the chat box the town in which your land is located and how many acres you own. And so I know that there may be some of you on here today that have multiple parcels. So maybe just choose one of those parcels and then give the total acreage just so we can get a sense of the geographic spread, and it will also help our speaker Liz um, better understand who she's speaking with. Oh, right. So Plainfield and Southampton and Alford and Byfield and Beckett, Middleton, Boylston. Oh, Blandford, great. Phillipston, boy, we got a great spread. Montgomery, Brookfield, Grammy and Holly, that's one of the all-time great screen names. Thank you, Grammy. Warwick, Buzz from over in Lincoln. That's great. So if you haven't done that, please do that just so we can get a sense of where you're coming from, size of your property, and it also um, lets us know that you're comfortable using that. So that's wonderful. Before I hand it over to our speaker, I just wanted to just let you know that this is one of several webinars that we're going to be putting together. So this is the second of 7. And tonight we'll be talking about using a will or trust to pass on your land. We're having one of these each month. It's the second Tuesday of each month. Sorry about that. Our December webinar will be on valuing your land financially and ecologically. So to get a sense of the assessment and what the value, the appraised value of the land is both financially, but also what some of the ecological characteristics you may want to look for to get a sense of your land as well. And then in January, talking about Chapter 61, and then in February, the specific land protection tools that you can use to protect your land in perpetuity, and then the tax benefits of those tools in March. And then in April, we're planning on just having more of a free form session where landowners can come in and hopefully we can help you plan out and map out some of your next steps to make sure that you can achieve your goals. If you are interested in any of those webinars and haven't signed up for those, you can go to masswoods.org/webinars and you can sign up for those. If you're interested in the recordings of these webinars, that's where we'll put all of the links to these recordings as well. So that page serves double duty. It both is registration, but it's also the repository, if you will, for all those recordings. And then the last thing I just wanted to mention is I just wanted to acknowledge our funders. We receive funding from the Department of Conservation and Recreation's Working Forest Initiative through the Service Forestry Program, and they give us funding for the last few years to reach out to landowners to help all of you make good informed decisions about your land with the ultimate goal of trying to keep as much land forested as possible and producing all these wonderful benefits both to you personally as well as to the Commonwealth, because our forests provide tremendous benefit. And I also just want to acknowledge my colleague Sarah Wells and Mount Grace Land Trust, who I partner with in organizing these events, as well as our co-sponsor, the Massachusetts Land Trust Coalition. Our friends over there have been very supportive, and we thank them for their support. So with that, you are here tonight to talk about passing on land in using wills and trusts. And when we talk to landowners and we survey landowners, we know that most landowners have as one of their goals to pass their land on, oftentimes to a child or children, but not always, sometimes to other people or heirs. But deciding who the land goes to is a very common goal. And we also know that landowners quite often use wills and trusts to pass that land on. And of course, we want to make sure that you have a good understanding of how to use those tools to the best for the best. So how can we maximize the impact and the effectiveness of those tools? Because they're wonderful for doing some things, but they don't do everything. So our hope tonight is to give you a sense of what wills and trusts can do for you in helping you meet your conservation-based estate planning needs. And to do that, we have asked our friend Liz Sillen to join us. Liz works she's a partner at Bulkley and Richardson. She works with individuals in all areas of estate and gift tax planning and administration. She works with nonprofit institutions, assisting with formation and operational issues, including regulatory compliance, as well as providing advice regarding charitable trusts and endowments. Liz is active in a variety of professional and community volunteer organizations. She has represented the Massachusetts Bar Association on state committee studying the spousal elective share statute, has been on a state committee studying legislation relating to digital assets, and is a member of various state and local bar associations and professional estate planning associations. She's a frequent speaker on estate planning and related issues. I know she has served on the board of the Franklin Land Trust and has interacted with a number of conservation organizations. I also happen to know that she's a landowner herself, or her family, in the great state of New York. And Liz has been kind enough to join us on a number of these events over the last few years and help us better understand some of the legal tools and instruments that can help landowners. So with that, thank you, Liz, for joining us, and I'm going to hand it over to you.
Thank you so much, Paul. I have enjoyed working with Paul for a number of years, as he says, on a number of projects like this. This, however, is my first Zoom, so I'm going to share my screen and I hope it works. If not, we'll try again. Here we go. Did I do the right one? No, this one maybe. Did that work? Yes? Thumbs up? Okay.
Well, Liz, I'm seeing your presenter view, I think.
Oh, you are? Okay. Swap? No?
It's better, but it's not taking up the whole screen.
Okay, so what have I done? So that's still not, you're still getting both?
Actually, I think I'm just getting the small square, which I think might be the preview.
Oh, okay, stop share. And
I'll tell you what, Liz, while you're doing that,
yeah,
my very bright friend Olivia reminded me that we have some polls that I forgot to launch. So while you
struggle,
get ready to launch, Olivia, do you mind launching those polls? And if you can just, if everyone can just fill out these polls, this will help Liz get a better sense of some of the characteristics you have as a landowner. So if you are a landowner, you can fill these out by just clicking on there. Here we go. It looks like we have more people answering. If you can click on. Looks like we've got 10 out of 41. Give it a couple more seconds, Olivia. All right, last call for the polls. And I know that there are a number of people that, multiple family members, obviously for one parcel, so we wouldn't necessarily have 41. So that sounds good.
I also got a message from Melissa that said the survey ended when Liz shared her screen. So if that happened with you, that's okay. This is just kind of gauging the temperature of the crowd. So I think maybe I'll end the polling now and we'll see who is able to respond. So thanks for that note, Melissa.
Great, thank you, Melissa. That's good. So about half have purchased it, and for more than half, there is a house on the property. So, and then another third have inherited it. I will let you know, because I'm a numbers geek. Those numbers are remarkably similar to landowners across the country in terms of proportion of landowners that have purchased their land versus inherited it. So, spot on. That's interesting.
How about that?
That looks great, Liz.
Okay.
All right.
All right, are
And
we ready?
I think we're all set.
All right, good. Sorry about that, everybody. I did want to say thank you so much to Paul and his team for inviting me to do this. Paul has been at this for a long time, and he really is devoted to helping landowners really try to figure out how to be good stewards of their land and how to deal with it. And he's got a number of publications, and I will be referring to them over time. This picture is from Sugarloaf, which is in Franklin County. I walk up Sugarloaf almost every morning and look out over this landscape, and it's hard not to really appreciate the amazing amount of land conservation that has gone on in our valley, and what a joy it is to have such beautiful farmland available. A lot of it has been preserved, and real estate land is in a special category in law and planning and for families. And it's I've worked in real estate, I've worked in estate planning for a long time, and I just find it fascinating that our connection to the land is just so deep and important. Paul is correct, I am generation 4 of some land in New York State, and all the wonderful joys that co-ownership with your cousins brings. So I am familiar with some of those issues. I was on the board of the Franklin Land Trust for a while. And so I am interested in land conservation. And actually, before I went to law school, I was both selling real estate, and then I was a real estate appraiser for 8 years, specializing in land preservation. So I come by it honestly. So today we're just going to talk about what estate planning is and wills and trusts. And even though Paul didn't advertise it, I am going to talk about limited liability companies, because it's really hard to avoid in this day and age. And so, what is estate planning? Well, basically, it's figuring out where you want your assets to go when you die, determine who's going to manage the process, and what tools are best suited to your needs. So why do you want to do it? And I always say that not having a plan is actually a plan, because if you don't make a plan, the state makes a plan for you. And what that means is that if you die owning real estate or any other asset, and you don't have a will or you don't have any plan in place, then state law will determine what happens to it. So right now, just this week, I'm dealing with a guy who died. He's got a bunch of land out in further west from here, Western Mass. He's in his second marriage. He created a will, but he never got around to signing it. And he and the second spouse had a prenup. And the idea was they both had long lives, and they wanted to give their assets to their own children and not to each other. And they agreed, that his property was going to go to his kids and hers would go to her kids. But that's not how intestacy works. And so he dies, and now she's entitled to 50% and the kids are, and we have to undo, a mess. I mean, it's not a big mess, but it's a mess. He could have easily just signed the darn will and everything would be simpler. So it's just a cautionary tale of, really it's a pain in the neck. It's not something you necessarily want to do, but putting it into place really is a huge gift to your family. The process of making a plan can be really, really difficult, especially if you're dealing with multiple family members and a lot of land and a lot of options. And I always say, don't box yourself into a corner. Maybe what you do now feels like it's the right solution for now. Don't feel like you have to stretch out into infinity and figure everything out. So, we generally start with, what's going to happen in incapacity or on death to the family, to the enterprise, and to the land. So you sort of really step back and look at the big picture first. So what's the scenario? So you want to keep the property in the family, or maybe you don't. And we can talk a little bit about that. Do you want to keep some or the land undeveloped, or maybe you don't? Do you know how you want the property is going to be managed, or maybe you don't? Do you have a clue as to whether or not there are going to be estate taxes that apply? And if so, do you know how you're going to pay for it? And are you interested in charitable giving or charitable purposes at any time? And are you wanting to undertake this activity during your life, or do you want it to happen at your death? When we begin working with folks on estate planning, even if the land and the family enterprise is the primary issue, you still have to step back and look at everything that you own and how you own it, because it's all relevant in the entire scheme of things. So that's going to include any business that you own, your bank accounts, investment accounts, retirement accounts, life insurance. So just sort of, it's we send out this questionnaire and people say, oh my God, I can't believe you're making me do this, but it is so valuable. And it's a great way to sort of summarize in one place everything that you own. And then we need to know about your family. What's the family tree? Who are the people that, would inherit if you didn't do anything? Who are the people who are important to you? Then you begin to think about what it is you want to achieve. As I said, think about tax issues and, your appetite for complexity. And from there, we begin to develop the plan. So we talked about, okay, do you want to keep it in the family or not? And what are the tools available? So as an example, I'm working with somebody right now who's got some land that he really, really loves. He's worked it. It's mostly forest land, but he's done an enormous amount of work on it. He loves it dearly. And nobody in his family wants it. He's talked to them. They just don't want it. So he is going to do a conservation restriction during life, which I'm sure Paul will talk about in the future sessions. And then at his death, he's going to give the land to the town in which he lives and have it be for public use. It took him a long time to get there. He couldn't believe that the family didn't want it, but darn it, nobody lives anywhere nearby. Nobody feels like they can walk the land. And so he had to come to that decision. And now that he's made it, he's really quite happy. So he's going to be able to do that by will. We have a family that created a trust, and they put all the family farm, all the farm equipment, they put all the land and the farm buildings into a trust. It's set up so that anybody in the extended family can live in, there's sort of an extra house on the property, and then there's the main house. The person who lives in the main house is going to be in charge of farming the land. The income that is generated from the trust is going to be distributed out first to mom, and then at her death to the various other family members. They are comfortable that it's going to last about 3 generations, and then off it goes. We have another family that their land, they have a land grant from King George. It has been in their family since the 1600s. And the current family owner who bought out his brothers and sisters has a second spouse, and he is so nervous about having this property at his death go out of his family. So it is an income producing property. We created a limited liability company, and then we created a second class of shareholders. And so at the death of the survivor of him and his spouse, it goes to her children, not his kids. The first time it's gone out of the family in 300 years. His siblings and their children have a right of first refusal if the kids ever want to sell any of their interests. So that gave him peace of mind that, yes, my wife's kids are entitled to own it, but if they ever want to sell it and any other family member wants in, we've got a mechanism. So there's just, there are tools available for figuring out different ways of keeping the property in the family. Paul knows I always do this, but I always want you to start by looking at your deed. It is so common for folks to say, oh, I know how I own it. I know how I own it. And you don't. 9 times out of 10, folks have not really looked at their deeds. And the deed will override your will, your trust, your LLC. If you don't understand how the deed works, no plan is going to make any sense at all. Prior to about 2008, Massachusetts had a sort of a bizarre system of passing property at death. So if mom died and at her death, the property went to kids, there was no new deed. The property would go through probate, and the fact of the will being admitted to the probate court would cause the deed to vest in the beneficiaries, but there was no document that said that anywhere. And so again, the King George family, the first time there was actually a deed was maybe 20 years ago, when we had to, move one thing from one family member to another, but otherwise it had all been through inheritance. And so we had to go through layers and layers and layers and layers of probate in order to determine who actually owned it. Since 2008, we now have a new law in place that makes it much easier. So anybody dying, inheriting property after that, there has to be a deed of distribution. So that's really made it a lot easier to figure out whether you actually own your property. So just briefly, if you look at your deed, and by the way, if you want to write down, masslandrecords.com is a website that you can go to. You should use Explorer and not Google Chrome to do it, so that you can look at the documents, but masslandrecords.com, and you can look up the deed and make sure that you can actually look at it. If it's a reasonably recent deed, say in the last 30 years, you can see it online. So let's say the deed says that I, Sarah, give it to Abe Smith. So that means that Abe owns it alone. He can transfer that interest by deed during his life. If he dies owning it, then it's included in what we call your taxable estate, and we'll talk about that a little bit later. It may or not, there may or may not be tax owed. And because it's owned in his name alone, it goes through probate. I also mentioned too that if you die owning property in your own name, you get what's called a step up. So your heirs inherit the property at the fair market value at date of death. So another common form of ownership is joint tenancy, either with right of survivorship or WROS or something like that, or tenancy by the entirety. With right of survivorship means that there's just any 2 people together who own together, or 3 people, or 4, or 5 or 6. And tenancy by the entirety is only available to a married couple. So if you're going to transfer property that your deed shows that you own as a joint tenant, if you're going to transfer the whole property, every owner listed has to join together. At the first death of a joint ownership, even if the will says it goes to the kids, but the deed, it's Abe and Barbara, and Abe dies first, Barbara gets it, even though Abe in his will said it goes to his kids, because it's joint ownership by operation of law, it goes to the survivor. So as I said, and another good example of this just to be aware of is Abe, Barbara, and Charles are joint tenants together. But Charles wants to deed his interest during his life to his own kids. He doesn't need the joinder of Abe and Barbara to do that. He can do it by himself. So he has destroyed the joint tenancy between the 3 of them. Abe and Barbara still own jointly, and Charles has distributed it to his kids, and they own as tenants by the entirety. As tenants in common with the other 2. So tenancy in common is sort of the default form of ownership. So if your deed says Sarah to Abe and Barbara, and there's no sort of descriptor after it, or if it uses as tenants in common, that's the most common form. And if you inherit it, it's going to be a tenancy in common. Without getting into the rights per se, what it means is that Abe now, if he leaves his share in his will to his children, they inherit his 1/2 share. And so they're basically segregated interests. So again, you do need to look at that deed. And just briefly, you may also be familiar with the concept of a life estate. That also is reflected inside the deed or possibly in a trust that may provide that. But so in this case, the ownership interest is segregated by time. Okay, we're going to talk about wills. So what does a will do for you? What does a will do? So a will is a document that transfers assets that you own in your own name at your death to whoever it is that you specify. So you can be really broad. You can say all my estate, real and personal. Even if you own property in Oregon and Indiana and Massachusetts, it's all bunched in and it all goes to whoever it is you set forth. Or you can be really specific and you can say all my real estate located in Sunderland, Massachusetts. And you may have a bunch of parcels in that town, but all those parcels that you own in that town are going to be devised to the people that you indicate. Or you can be really minutely specific and you can say, I'm my land that's described in book blah, blah, page blah, blah, and the registry of deeds, then that's the specific parcel that goes in accordance with your directive. If you're going to be doing this, you do need to think about, okay, what about if the person I give it to dies before I do? What happens then? So I call that going down the what if trail. So you have to think, okay, if that person doesn't survive me, where does it go next? And you always need to sort of have that second thought in mind, because and most of us don't get to pick when we die. Another thing I wanted to mention is if you live out of state and you die a resident of another state, your will may get probated in that state, but then you also have to do a probate in Massachusetts. And that's because real estate, it has a physical location. And so in order to transfer title, it has to be in this state and there has to be that official transfer of ownership. So a couple examples here. So worked with a family that again has had farmland in its family for a couple hundred years in that case. And they just didn't feel that they wanted to be too prescriptive as to what the kids were going to do with the land. None of them lived in state at the time. So the parents decided they were just going to, in the will, we're going to leave it to our kids. And so parents both died. It went to the three kids, and the kids co-owned it for a while as tenants in common. And then they decided, you know, this is really kind of clunky. So they ended up creating a limited liability company. And now they rent the farmland out to a farmer. One of the kids is a manager who collects all the rents and does the leases. And that solution has worked out for them, and the parents didn't need to decide. We have another case of the family, another farm family, where one son was the farmer, the dairy farmer, and the other three kids were not involved in the family business at all. And the parents really, really wanted that farm to stay whole and in farming. And so they left the entire farm to this farmer's son. And then they left all their other assets among their other three kids. That one didn't work out so well. The son who is the farmer wants to sell the farm, and the siblings are really ticked off. But so that doesn't always work, but it is something to think about. So again, the will does override the intestacy rules. You can, in your will, put a conservation restriction on. You can give a life estate to somebody, let them live there for life, and then direct where it goes at their death. And you can also create a trust in a will. The other big options for how you keep it in the family are, as you can tell, I've referred to our different kinds of entities. We're going to talk about trusts, and we're going to talk about limited liability companies. So trusts have been around a very long time, and I'm going to guess that a number of you, I was fussing with the PowerPoint, so I didn't see how many of you have done estate plans or how many of you might have trusts. But a trust is a very old tool, and it's a very, very flexible tool. And I think the reason that it's been around for so long is that it gives us so many different ways to design things. It's a very, very open platform. But what it kind of does is it kind of breaks ownership down. You've got the corpus, which is the real estate. And then you've got the person who has the legal title, who's called the trustee. That's the person who has a fiduciary duty to manage the assets for the benefits of the lucky ones, the beneficiaries. The beneficiaries are the people to whom distributions are made. They're the people for whom the assets are held by the trustee. So you've got the trustee, the manager, the beneficiaries, the recipients, and then the corpus inside. The person who creates the trust and puts the money in or the land in is called the settlor or the donor. As I say, common uses in this context is we will often transfer family lands into a trust for several generations. Depending on how it's designed, it can be safe from creditors. It can be safe in some instances for divorce issues. It can also protect in the event of individuals who might have some personal issues. We can also use a trust to manage assets during someone's life. You can put assets in there while you're alive and manage them yourselves. And then when you lose capacity, the trustee, a successor trustee to you, can take over and manage the assets for you. We use trusts a lot for tax planning, especially for married couples. And we can talk a little bit about that as we go down. Also, minors and individuals with disabilities, it's often not appropriate for a disabled individual, and it's also not legal for minors to own assets. And so we often will use trusts for that purpose too. Assets can be managed for the benefit of these folks. They get the benefits, but they don't have to manage them themselves. And you probably have heard of the concept of avoiding probate. Any asset that is transferred, so you take the deed and it goes into the trust, then that asset will pass according to the terms of the trust, and it avoids probate at the person's death. All those acronyms below there's tons and tons of different kinds of trusts. The first two are charitable kinds of trusts, then there are grantor trusts, and then there's qualified personal residence trusts. There are trusts for individuals whose spouses are non-citizens, and there's trusts for different kinds of discounted transfers. So again, when we do trusts, we whatever you want, you can put your requirements for how the land gets managed. You can create a structure for how the property will be managed over the next few generations. You can require that it stay in the family. You can allow it to be sold. You can allow the trustee to make distributions. You can keep the money inside the trust. And the one thing about it is at the bottom there is that generally trusts aren't structured to allow the beneficiaries to transfer their interests until the trust is terminated. So that is one aspect of a trust that can sometimes not serve your purposes quite as well. So again, we take that deed, and the deed, Abe owns it, and now he's transferring it to Barbara and her successors, and Barbara's been named the trustee of the Abe Family Trust. So now what he's done with the deed, showing that he's transferred that property to the trust. And when Abe dies, that land passes in accordance with the terms of the trust. And depending on how the trust is structured, it may or may not be included for tax purposes. You can create a trust in your will. that just springs into life at your death. That's called a testamentary trust. You may have heard the term inter vivos or living trusts. Those are separate documents from the will, and the trust is created separately from the will. It can be funded during life, or it can be funded at death. Living trusts can be revocable or revocable, depending on your preferred terminology, or irrevocable or irrevocable, meaning they can either be revoked and changed and amended as much as you want, or if it's irrevocable, it's basically a steel box. It's not supposed to be changed. Something about in Massachusetts is that trusts cannot exist in perpetuity. So they can only list, there's a rule against perpetuity here, and without going into a lot of detail, basically trusts can only last for about 3 generations or 90 years, whichever is longer. Just briefly also, just so that you know, you may run into this here, Massachusetts is one of only a few states in the country that allows for the creation of something called a nominee trust or a realty trust. They're not really trusts at all. They're very often very much misunderstood, but they are a very useful tool. They're sort of like, they're like a trust in reverse or through the looking glass, because unlike a normal trust, in a nominee trust, the beneficiaries actually direct the trustee into what the trustee can do. Unlike the other way around, where the trustee is in charge and the beneficiaries just receive. It can be useful in a number of different ways, but just be aware that it is a peculiar Massachusetts creature. And then limited liability companies, obviously there's also partnerships, general partnerships, limited partnerships, all different kinds, but the limited liability company has really become the sort of go-to corporate form in Massachusetts. And even though it sounds like you're really talking about a major corporate entity, it can be created for a house. It can be not your primary residence, but something that you might keep as a second home. It can be created for the family farm. It can be created for your forest land. And in this instance, then the deed would be Georgina. She has created the Holly Farm LLC, and so she deeds the property into Holly Farm LLC. The limited liability company is run by way of the operating agreement. That's something that is just as flexible as a trust. You can dump anything in there you want, showing how you want things to be managed. It's very, very flexible. If you choose not to go into a lot of detail, there's sort of a state law that defaults how it all works. In this example, we're saying that it's set up so that there are members who are kind of like the beneficiaries, and then there's managers who manage, who's sort of like the trustee. So one difference between a limited liability company and a trust is that the members, the beneficiaries, if you will, can transfer their interests. And it's not by deed, they're actually transferring a limited liability company membership interest. When we're doing these for families, we almost always, at the request of the family, limit transfers to other family members, or if there is a desire to transfer it out of the family, there's a right of first refusal. As I said, I think, we're talking about the family that had the family land that has been there for 300 years. The LLC has worked really well for them. So to create that, you actually do have a little bit of a corporate hassle factor. You do have to file a certificate of organization at the state's office, and you have to pay $500 a year to keep it going. You do have to, as you do with a trust, once it's irrevocable, you do have to file a tax return for it, even if all the income is distributed out. Another piece of it is that by the word limited liability is put in place in order to give you an idea that the members and the managers are not personally liable. And so you protect, there may be if something happens in the enterprise, only the assets of the enterprise are at risk and not the personal individual's other assets. And generally, as I said, it's a pass-through entity, so the tax, if there's income, it goes out to the beneficiaries. We also will generally use this as a mechanism to limit the ability of a spouse to get at this for divorce. And so it's, and creditors, there may be a right to elect against it, but the company can buy it back so that it doesn't go out of the family. So again, we look at, we've looked at the family, we've looked at the land and what you want to do there, and then we look at all the other assets in order to understand everything that you have, and not just looking at the family enterprise in isolation. So now, how about the management of the land? So you can be very laissez-faire and just say, I trust my kids, I trust my family members, everybody there can make their own decisions. Or you can, in a trust, be very, very managerial and tell exactly what you want to have happen or how you want it to work. And similarly with an LLC, you appoint a manager, and then the manager can manage, or the members appoint a manager, or the members manage, but somebody's got to manage. I was going to talk about a family where the individual was a farmer again. This was about probably 12 or 13 years ago. He was a farmer in Franklin County, and he was recently divorced, and he had 3 young children, and he went up snowmobiling in Canada and died. And fortunately, he had a plan in place. He had created a trust, and his sister was going to be the trustee for the benefit of his children. All the farmland is held in the trust. She then was directed to hire a manager for the land and for the farm. And the manager ran the farm for 10 years or 12 years, and any of the net income was used to help support the kids as they grew up. The plan was to hold everything in trust until the youngest child was 25 years old. The idea being that maybe at that point, all 3 kids might have a sense as to whether or not they wanted to farm or whether they didn't want to farm. And he had really hoped, especially that his youngest was going to be interested in farming. But the youngest turned 25 this year, and he's not interested. So we put the farm on the market, and it was sold. The kids got the cash, and the trust was terminated. So that's sort of an example of a way in which the land got managed for a period of time. And now it's still a farm, but it is no longer in the family. But the estate plan, I think, worked very well to accomplish what this guy would have wanted to have happen, other than the fact that he wishes his son was going to continue. But so again, looking at your family and motivating you to figure out what it is that you want to accomplish. As I said before, the intestacy laws may or may not reflect your wishes. Second marriages, children from the first, children that might have issues, be it divorce, mental health, money issues, substance abuse. There's the issue of geography, people being really far flung, and then there's the issue of the costs of running the property, and how are you going to reconcile that? I'm working with a family right now where the absolute major asset is their land, and it's worth quite a lot. And we're trying to figure out how it is that once it goes to the kids, how we're going to deal with the estate tax problem. Yeah, tax. So there is something called an estate tax. It is imposed on the assets that you own at your date of death. There's 100% marital deduction. So anything that goes to the spouse, there's no tax, on the theory that they'll get you at the second death. There's a federal estate tax and there's a state estate tax. Federally right now, it's pretty high. It's 11.58 million per person in 2020. It's going up to 11.7 million next year per person. And whatever the first spouse doesn't use can be ported over to the second spouse. So you're looking at, you know, $23 million before there's an estate tax. And once the estate tax hits, it's a 40% tax on everything over that amount. The thing that's a little confusing right now is that the current law is going to expire at the end of 2025, and it's due to go back to $5 million. You know, we don't know what the politics are. You know, there's a lot of debt that's being incurred now with a lot of money going out, whether there's any, it's been kind of a political football. So we really don't know what's going to happen. There's a lot of chatter as to what it is we're going to expect with regard to the federal estate tax going forward. Massachusetts, meanwhile, is plodding along behind the curve, one of very few states that has an estate tax, and tied with Oregon. I think there's one caller in Oregon for having the lowest threshold in the country. So instead of an exemption, it's a threshold. And so what that means is that it's $1 million per person. If your assets are 999,000, there's no tax. If it's $1,060,000, it taxes you from $0, and it's a $33,000 tax from the start. You can't port over that million to the surviving spouse. So that's why we end up doing a fair amount of tax planning with the use of trusts. If you own real estate in Massachusetts, but live in another state, Massachusetts only is going to tax the real estate in this state. Similarly, if you live in Massachusetts and you've got significant real estate in another state, Massachusetts cannot tax that real estate. Most other states have a much higher threshold or have no estate tax at all. Things that you give for charity, total charitable deduction. And as I said, there is a marital deduction. So anything that goes to a spouse, there is no tax. So again, when we're doing planning, we have to figure out, okay, what's our estimate of the estate tax that's going to be owed? Is there enough liquidity? If not, how are we going to deal with you have to pay this tax 9 months from date of death. And if you're allocating assets differently among children, you kind of need to make a determination as to how you're going to allocate the estate tax. So again, if I haven't bored you completely, we devise the plan, and then we do a will, we do a trust, we think about an entity, we think about how we're going to allocate our assets and whether or not we're going to do gifting during life or wait until death or make a gradual turn. And hopefully you're motivated enough, because if you don't make a plan, it becomes a plan. And that is the lesson of the day. So that is all I have.
Outstanding. Thank you very much, Liz. That was very informative. And so we've got plenty of time for people's questions. This is a unique and great opportunity to ask some questions of someone that has obviously a tremendous amount of knowledge and experience dealing with land and land issues. So why don't I open that up? Does somebody have a question they would like to ask Liz? And you can just unmute yourself, or you can put that into the chat if that's easier, like we did at the beginning.
Liz, I do have a question. Bill Honey in Cummington. I own 90 acres, no home on the land yet. It's in Chapter 61B. We have a forestry management plan going. Does land being in Chapter 61 have any bearing whatsoever on will and estate planning?
Well, yes and no. You know, you're allowed to transfer property among family members, but if anybody is going to try and take it out of chapter, obviously, then it triggers a right of the town, right, to purchase from you. But it doesn't restrict you from, there's no prohibition from, you're freely allowed to transfer it. It's just a matter as to whether or not it's going to be moved out of the chapter.
I see. Okay, very good. Thank you.
Yes, and we'll actually be doing a whole session on Chapter 61 if that's of interest in January. But as Liz said, that lien goes with the property. So if you transfer that land in current use in 61 to, say, a son, daughter, or an heir, that lien would go with the property. And unless that land use is changed, if they keep it the way that it is, then there would be no right of first refusal. However, if they decided to build houses on it or sell it for some other land use, then the town would be able to get that first right of refusal.
I've got a quick question for Liz.
Yeah, James.
Yeah, hi Liz. Thanks for the great presentation. And naive question, I guess. You mentioned in Massachusetts there was, if I remember right, I think it was a $1 million threshold.
Yeah.
Is that $1 million per current owner or per recipient?
It's based on a date of death. So if you're a partial owner of something that's includable in your taxable estate, you have to have an appraisal where there's a determination of the value of your partial ownership. So say that you co-own with other folks, you have to hire an appraiser who not only values the asset, but then has to figure out your proportionate valuation. And sometimes that can include not just a strict dividing in accordance with the percentage of your share, but there can be something called a discount that's applied because it might be really difficult to sell your partial interest or something like that, if that answers your question.
I'm a little confused. So I'm actually asking in this case about some land that my parents own, and they'll be potentially passing it on to my brother and myself and our families.
Yeah.
So is the limit, $1 million per, parent, or
Yeah.
is it?
Yeah.
Okay, gotcha. Thanks.
Liz, I have a question. This is Deb and Neil from Beckett. For the chapter land, for the valuation for estate tax purposes, if it's in chapter 61 land, how is that entered into your estate valuation? Is it the valuation, the reduced value of the land, or is it the full value?
That's a really good question. I thank you for asking that. So because that is something that can be removed, the chapter designation does not affect the estate tax valuation. If you have a conservation restriction, obviously that will permanently lower the value of the land. But for Massachusetts and federal estate tax purposes, chapter designation does not lower the value.
Okay, so it's valued at full value.
Right.
Yeah, unless it has a conservation
Right.
restriction on it. Okay, thank you.
Yep.
That's a great question, Deb.
I have a question.
Oh, go ahead, Andy.
We've had quite a bit of land left in our family, from my grandparents to my father and uncle, and now to my brother and I. And my brother recently passed. We have what we call an LLC formed, and we have a buy-sell agreement that we had with the two of us for the business. Okay, the business is separate from the LLC. Okay.
So the LLC is for the land and the business is
Yeah,
another entity.
let's call the LLC Dandy, Dan and Andy. Okay, Dan and Andy, Dandy LLC, and then we've got our lumber business, which is separate. That's a corporation. Okay.
Okay.
We're not talking about the lumber business. We're talking about the Dandy LLC. Now you were talking about deeds. Okay. Maybe you answered the question. I don't know, but if the land has been owned by my brother and I, and he recently passed. Does that mean that all the deeds that were there that had our names on it now have to have the names of his heirs on those deeds?
Depending on what his will says, but you're describing as the land is currently owned by Dandy LLC.
Yes.
Okay, so that means that the deed should show that the owner is Dandy LLC and that you and your brother are the members. And so I'm going to guess that your brother in his will devised his interest in Dandy LLC to his kids. So
Correct.
his 50% share will be owned by his kids.
Right.
And your 50% share will be owned by you. And the deed will not change at all because Dandy is still the owner.
Okay, that's where I was a little confused when you were talking, but now I understand what you're saying.
Yeah.
Okay, so we don't need to go through any more legal stuff to get the stuff, their names on it. Dandy LLC owns it.
Dandy LLC owns it, and then there'll have to be a transfer of the membership interest to his kids, but that's not a deed. That's just a piece
It's part of his
paper.
will and trust, and that's who we left it to.
Yeah.
Okay.
So Liz, I just want to jump in because that's a great example of how and you're the one that taught me this. Everything I know comes from Liz. An indirect. So if I get it wrong, I guess I'm really going to be embarrassed.
Yeah.
There are direct ownerships, like you were pointing out, like the tenants in common and other individual and so forth. But then there are these indirect ownerships, like a trust and an LLC. That those are the entities that own the land, not necessarily the person. It's the entity, the trust or the LLC. And one of the advantages of something like an LLC in Andy's case, in his example, is the ownership stays the same. And I'm assuming it's the operating agreement of the LLC that allows people to come in and out of it within the boundaries of the operating agreement. So if you want to shift ownership, I don't know if shares is the right phrase, but if you want to shift ownership, you can do that within the operating agreement. Is that right?
Sure. Well, the operating agreement generally acts more as something that will prohibit certain transfers, but it's usually allowed to freely transfer among family members. Andy and his brother can freely transfer among themselves. But yes, good. Yes, A+ on the learning.
All right, good. All right, thanks, Liz. All right, other questions?
Yeah.
Yeah, go ahead, Deb.
On that same genre, Liz, so say the will designated the property to go directly into a trust. So you said after 2008 that you need to have the deed change. So if the property went into a trust, would you then have to have some sort of deed of distribution to put the trust name on it, or does it just follow the trail from the will?
Yeah, that's a great question too. So if at death the property is being transferred into a trust, generally there will be a deed. You should have a deed that reflects that.
A deed of distribution that shows that the trust now is
the owner. Yeah.
Okay, thank you.
I just want to reach out to Rebecca Cutting. You would put a question in the text, or excuse me, in the chat box, and I just wanted to make sure that answer satisfies your question. And if not, if you can just unmute and let me know.
It didn't.
Okay. All right. Well, I'm glad I asked, Rebecca. So
maybe I didn't frame the question right, but I wanted to follow on a question to Liz that came about 4 or 5 questions earlier about the effect of the preferential assessment 61, 61A, 61B. Have a situation where we have farmland already in an agricultural preservation restriction, but it's also assessed under 61A since it's permanently restricted. So my question really was sort of a twist on, if it's permanently restricted and the purpose of 61A is to avoid changes in use, would that right of first refusal still exist? I suspect yes, on transfer to another entity, but still be a farming.
Go ahead, Paul.
Yeah, unless there's a change of land use, then the right of first refusal doesn't kick in. And if you have an APR on the property and it's then going to stay in active agriculture, even if you transfer the ownership to, say, sons, daughters, whoever, then that right of first refusal would not kick in.
But outside the family?
As long as the use isn't changed, it shouldn't,
but
it
it
won't,
should.
it won't trigger
Right.
that. Yeah.
Thanks.
And in fact, a lot of people, since we're in a home rule state, it's not uncommon for someone that has either an APR or a conservation restriction on their property to also overlay a current use program for the assessment. Not all local assessors recognize reflect your assessment because of the conservation easement. So a number of landowners I know will, even though they have an easement on and it should reflect that in the assessment, they throw a 61 on top to make sure that they're receiving that tax break.
Yeah, understood. I've seen that in operation too. Thank you.
Of course, and I'm sorry I didn't answer that clearly the first time. Are there other questions? I hope. It's such a great opportunity. I can't see everybody.
Oh, we have a question in the chat, and it
Great.
says, if we want to keep the land for direct descendants, is there a way to protect our children's inheritance from a divorce?
Not an unusual question at all. Massachusetts is a tough state, I have to say, because unlike other states like New York, for example, assets that you've inherited in New York are not brought into the division of assets on divorce. Massachusetts, unlike New York and other states, says everything is on the table. We get to take everything into account. Now, what we can do is discourage assets from being subject to division on divorce. That's why often in a trust, an irrevocable trust, if a child has an indivisible interest, so it's owned with several siblings, there's a value to that, but the court sort of doesn't really have a way to deal with it. So the value is included in, sort of the analysis as to what gets divided, but rarely, I've almost never seen a court say, then, okay, then we're going to pull, her 1/4 share out. What the courts increasingly do in Massachusetts, to my intense irritation, is they'll say, oh, but we'll do an if, as, and when analysis. So they'll say, okay, the asset is held in a trust for the benefit of the 3 kids. If there's ever a distribution that goes out to the divorcing kid, then that gets split with the ex-spouse. So we do the best we can. We can discourage the court. We can make it harder, but it's hard to do a perfect protection here in Massachusetts.
Does that answer your question? I hope. If not, please feel free to unmute.
Yep.
Great. Excellent. Excellent. Other questions?
I will occasionally hear from landowners that they're wondering how to protect their assets and thinking about look back periods with nursing homes.
Mm-hmm.
You want to touch on that?
Sure. Yeah, that is a big question. So this has to do with Medicaid, Mass Health. So when somebody needs long-term care in a nursing home, so not an assisted living facility, not in any other kind of independent living facility, but nursing care, and the cost of care is very, very high. Mass Health, which is Medicaid, will pay for the costs of a person's care if they qualify. And how do you qualify? You qualify for having $2,000 worth of what they call countable assets in your own name at the time that you need to qualify. And so one of the big issues often especially for farm families, is they've got a lot of land with a lot of value, but they don't have a lot of liquid assets to pay for the cost of nursing home care. And so often folks will try and come up with a way in which the land gets protected without having to liquidate it in any way in order to pay for their care and qualify for Medicaid. So one can transfer assets either to their kids, to other people, or to an irrevocable trust. We talked about revocable and irrevocable. An irrevocable trust is one that cannot be revoked. It's a pretty drastic thing to do because that basically means you are giving that asset away. It is no longer yours and you have no right to the principal. But if there a 5-year period passes and that land was transferred into an irrevocable trust or to the kids or somewhere else, and 5 years passes and you don't need to, and after that 5-year period, you are going to qualify for nursing home care, then that asset is no longer counted. If you need to go to the nursing home 4.5 years later, that the value of that asset is brought right back in. So you need to plan in advance for 5 years or it's not effective. But it sometimes needs to be done. We've certainly seen, particularly as I say with farm families, where there's a real concern that there just is not the liquidity to pay for the extraordinary costs of care. And yet on paper, somebody looks like they're pretty wealthy because they've got a lot of farmland that's worth a lot.
I have another question.
Yep.
Getting back to that Dandy Real LLC. My brother did all of the work on this, okay, and he's gone. I'm assuming that all of the land that we own is under Dandy. That's what, but let's just say hypothetically that it's not, that some is, some parcels we own do and some parcels we own are not. What would happen then?
So sort of going back to the idea, whatever your brother's will says is going to, so if you guys own, I'm going to assume you own as tenants in common before you transferred it into Dandy, rather because you inherited it. And as I said, it's pretty rare for people to inherit jointly with right of survivorship. They usually inherit joint or as tenants in common. So if you're a tenant in common and Dan dies, then his will directs where his LLC interests as well as his interest in his land goes. So you need to look at his will. It doesn't automatically go to Dandy unless he directed it there.
I'm sure he did it that way. Okay, I'm just hypothetically wondering if this land is not under Dandy, if there's something that could, happen here to his
maybe
with
you,
heirs or whatever.
yeah, maybe his heirs and you could join together and transfer it into Dandy so that everything is all together.
Okay, all right. We just something we got to look into.
Yep. Mass records.
Liz, there were a couple more questions here in the chat. So the first one is, how does the Homestead Act affect the nursing home payment and land transfers?
Doesn't. So a declaration of homestead is a very easy document that you can add into the registry of deeds that provides, there's an automatic 125,000, or you can file a declaration that gives you $500,000 worth of protection against creditors under the theory that we don't want you to be displaced from your home. And so even though a creditor may say they want to put a lien on your property or something, they can't force a sale. But there are exceptions. And so the exceptions would include the state and Mass Health. Now, that said, I do want to say that if there's a community spouse and a spouse that's going into the nursing home, Mass Health isn't going to make you sell the house. The house is exempt. And also, if a person is needs to go to a nursing home and maybe it's not permanent, the house initially is not something we call a countable asset. And so in that $2,000 you're allowed to have, the house is excluded. And it's only when the nursing home says, you know, Liz is never, ever going home again, then my house becomes a countable asset. And then I either have to sell it or I lose my Mass Health eligibility until it's sold. So the Homestead Act, it per se is not necessarily helpful, but having a surviving spouse a community spouse can help. Or if the person in the nursing home intends to return home, it's not included. And it's Medicaid. Medicare and Medicaid are different. Medicare is eligible to everybody. Anybody who turns 65 is eligible for Medicare. Medicaid is what pays for nursing home care, and they're very different programs.
Great. Here's a trust question for you, Liz.
Yep.
If a trust is created by way of a will with children as the eventual trustees, do those children need to create a new trust or amend the trust to pass it through the generations?
Great question. My lawyerly answer is it depends. You read the trust, and what does the trust say? If the trust was built to last for several generations, then you set and forget, you're on your way. If the trust says, I create it by the will, the kids are the trustees, it lasts for their lives, and at their deaths, it goes out to their kids, then they're going to need to create a new trust in order to continue it on after that.
Rob, if that doesn't answer your question, please let me know. Another question regarding, I believe, Medicaid. So can you protect your land from Medicaid through a revocable trust as well as an irrevocable trust?
No. Just by virtue of the fact that a trust can be revoked, Mass Health says that we don't care. It's as if it's your own. You have not divested your interest.
Great, thank you. Chris Fowles asks, I'm assuming, what are the benefits of a life estate, and is there still a 5-year look back for medical costs? I don't know if he means Medicaid.
I assume so. So the benefits of a life estate, before we get into Medicaid land, well, even including Medicaid land. So one of the things that people like about a life estate is it avoids probate at death. So if I have my house reserving a life estate but transfer the remainder interest to Paul, that means that I get to use the house for my life. I pay the taxes, I pay the insurance, and at my death, it automatically transfers over to Paul without any probate or anything, and it becomes his. He gets the benefit of the so-called step up at my death. So he owns the property not for the $75,000 that I bought it for in 1983, but for the, whatever, $300,000 it's worth at my death. So if he wants to sell it, he is going to not have much capital gain. So that's a huge benefit to him. For a lot of people like it for Medicaid planning, in part also because at my death, if I did qualify for Mass Health can put a lien on a property that is a probate asset. Oh, I transferred it to Paul and it doesn't go to probate. So they can't put a lien on the property. However, because I've retained that life estate has a value. And so say it's $300,000 of a value of a house. When I'm trying to qualify for Mass Health, my life estate, in other words, my remaining life, the value of the property that it's attributable to me for my remaining life, is potentially a countable asset for Mass Health purposes. So what I've given to Paul, if 5 years have passed, you're right, that's out, but my life estate is still in. So it can work very well if if I go into the nursing home never declares that I am not going to be eligible to return home. So they think there's still a chance Liz will go home. So the value of my life estate is not a countable asset. I die, very timely, and Paul gets the house. So it never gets as a countable asset for mass health purposes. I transferred it to Paul more than 5 years ago, and because it's not a probate asset, there's no lien, so he gets it. So that's the win-win scenario for a life estate for mass health purposes.
Thank you.
Great. Thanks for the question, Chris. I think we have time for one or two more. I want to make sure we get to everybody. Feel free to either speak up and unmute yourself, or actually just type it into the chat.
Yeah, I just have a comment to make, Liz, and you did point this out right at the beginning, is to know your deed, to look at your deeds, especially if you've inherited the property from generations past. There's a lot, deeds were not transferred properly generations ago, even 40, 50, 60 years ago. So now if you don't have a real handle on what your deed says, you could be in a lot of trouble when it goes to pass on to the next generation. So I just want to make that comment.
Yes, it is true. Or a lot of those descriptions are pretty wild to read too. So.
And Liz, that can be a good place to start, yes, in terms of wrapping your mind around your estate plan, getting a sense of what the ownership currently is in, how it may transfer if you do nothing, and then making changes from there.
Yeah, and it's not always simple either. I mean, as Deborah kind of points out, masslandrecords.com, and you go in there and sometimes there'll be, 8, 10 deeds, and sort of deciphering which deeds are relevant, which ones aren't. Was some piece deeded out? Is there still a remainder? Did they change the description? It can be kind of an exciting little hunt to figure out the ownership, especially when property's been in the family for a long time and little pieces have been carved out. So it's a good exercise.
Great. Chris, I fear that I may have cut you off. Did you have a question, another comment?
It's in the chat.
Oh, I'm sorry. Oh, look at you're so efficient here. You mentioned, I think, donating the CR to the town. Does the town have the ability to refuse a CR?
Well, what I mentioned actually was donating a CR to a land trust organization, and then he was going to donate the land to the town. Because the town can, but the CR, as you know, requires that somebody police it, and they have to monitor it, and every year go through and make sure that the terms of the conservation restriction are being honored. And so many towns don't feel that they're in a position to do that. It often requires a land specialist and everything. So it's more common. I mean, Paul and Olivia and Kate, Sarah, let me know if that's changing. But last I knew, most towns would prefer to just receive the protected land.
Sarah, do you want to jump in?
I was just going to put in the chat that it really depends on the town, but often starting with your local land trust, if there is one, can be a helpful way to gauge what's in the realm of possibility for your property.
And that can be a good lesson in terms of if you do have the desire to donate an easement or donate land, having some of those conversations ahead of time so that a town or a land trust isn't surprised at the time of your will opening that and that may or may not be a good fit. So maybe having those conversations ahead of time, working out some of those details, making sure it's a good fit for everybody and that your own goals will be met is a good way to go. So I think I'm going to draw this to a close. I hope that you've been able to glean some useful information from Liz's fantastic presentation, as well as the questions, excuse me, of other landowners. I think more than anything, I just want you to walk away with this sense that you have options, that you can achieve your personal goals and your financial goals, but it does take some consideration. It takes some thinking. It takes some work ahead of time, excuse me, to find the right match of tools. Working with a professional that has experience with land, as Liz said, land is a very, particular, unique asset. So finding an estate planning attorney that has experience working with landowners is very important, because they will have a better sense of what the options are and how to meet your goals. So I hope you have walked away with the sense that there are tools out there to help you meet your goals, that there are people working locally to find that. There are some resources we have. Protecting Your Legacy and Using a Will are two of our resources. And we also have a website, masswoods.net, excuse me, or masswoods.org. You can get there both, where you can find an attorney that works in your town with conservation experience, as well as your local land trust. So with that, I think I'm going to hand it over to Kate, who is going to just walk us through in the last minute or two. We're hoping that you'll help us out with an evaluation so we can continue to improve our programs. And I just want to thank Liz, while I still have the floor, for your time and sharing your vast experience and knowledge. So thanks, Liz.
Oh, thank you guys. And you've been a great group. And if anyone wants to email me, by the way, feel free. I'm happy to answer quick questions as follow-ups. Don't hesitate.
And yeah, if you just have a moment before you leave, there's a link to an evaluation form in the chat, and we would greatly appreciate if you could take just a few moments to fill it out so that we can keep improving on these webinar series. And there may even be a special surprise if you complete the entire evaluation. Not promising one, but there might be. Who knows? You'll have to take it to find out.
Very mysterious. So Kate, just to confirm, you can just go into the chat and just click that link. For those of you that don't do a lot of zooming, so to speak, you can just go right in and hover over that with your mouse and give that a click, and that will launch the survey, and you can take it from there. So we greatly appreciate it. The whole webinar series is new to us. We're more comfortable in a VFW with some chicken parm and salad and around some tables. So this is all very new to us. And but we have families from around the country and around the state, and that's pretty neat that we can do this through a webinar. So, but we'd love to get your impressions as to how it went and how we can improve. So thank you.
And we can email it out to folks who are calling in and can't see that link.
And once you've taken it, I wish you a good night. And if you want to stick around because you have a question that I can help with, or because I can send you some information, feel free to do that. Otherwise, I hope to see some or all of you back in December when we're talking about how to value land both ecologically and financially. Thank you, Nate. Hope you're well.
Can I ask one question? I put it in the chat, but it was kind of long.
Oh, I'm sorry, Melissa. Go ahead.
Paul. I know, I waited till the very last minute, but then I wanted to ask it. But I put it in the chat, and someone had said something about conservation restriction. But if we have a property that we want to sell the home with a little bit of acreage, but then keep the land for logging and selective harvesting, how do we protect that other land to keep it to stay in the family?
So Melissa, you're breaking up a little bit. I just want to repeat what I think I heard you say.
I think people froze.
And you can tell me if I'm right or wrong. So based on what you said and based on what I'm seeing in the chat, it looks as though you've got a piece of property with a house on it, and you're interested in selling the house and maybe a few acres of land around the house, so that would be gone. And then what you would be left with would be just a piece of property, and you're interested in protecting that but maintaining your right to active forest management. Is that right? Okay, that's good. Sarah, do you want to take that?
A conservation restriction is a good tool for that because the underlying ownership in the land would stay with your family, and you can craft it so you can continue to do that type of management.
And Melissa, we will have an entire session on this in February, I believe. In February, I think, is the conservation restrictions and land protection tools. So we have our publication, Protecting Your Legacy, and in there describe some of the tools that you can use. One of those is a conservation restriction. So that would sort of whet your appetite or may help answer your questions. And then we'll be focusing our entire webinar in February on this very topic. If you need information before then, say so and we can reach out to you. I mean, we don't want you to wait, particularly if you're making a decision. So is that something you would like us to reach out to you? You're muted.
It will be happening, but it won't be happening soon.
I didn't quite catch that. Can you type it in, Melissa, to the chat?
I'm hoping. Oh, I'll type it in. Yeah.
Okay. Yeah, type it in. That way I'll get it. Thank you.
Okay. Okay.
Thank you, Katie. It's good to see you. Oh, okay. So why don't we just reach out to you and maybe we can have a conversation with you. And yes, and I'm assuming Olivia, I'm assuming from her registration, we have a way to reach out to Melissa. Great.
Melissa, just in case, can you would you be comfortable putting your email in the chat just in case you're registered under a different name or something?
Sure.
Thank you. I appreciate it.
Good call, Olivia. That's why you make the big bucks.